Well, good morning, everyone. Thank you all very much for cooperating in this slightly novel, well, it's no longer novel, way of conducting proceedings. I'm sorry that we've had to adjust the timings of the hearing because at the moment we can't have two WebEx meetings at the same time. But I'm grateful to you all for agreeing for the adjustment in the timings. The second thing that I want to mention is that a case which may bear on some of the issues in this case was had in January, and Mr. Hoskins, I think you were involved in that case. Lord Sales was one of the members of the Constitution that sat in the case. The rest of us have decided that we should not read any draft judgment in that case before we complete the hearing in the present appeal. But obviously, we will read it when it is handed down. And after that, we will give the opportunity to the parties to make written submissions if they wish. It may well be that they don't consider that it is necessary. If they wish to make written submissions about the effect or impact of the judgment in that case on the present appeal. Right. Well, the final thing that I should say, the rather prosaic matter is that since we are starting at 10 p.m., we shall take a break of about 10 minutes at 11:30. We're very grateful to the parties for the very helpful printed cases, which set out the issues very clearly and which we have all read. Therefore, I'm confident that the case can proceed with, how shall I put it, economy. Good. Now, Mr. Hoskins, you appear with Mr. Cook, Mr. Leith, and Mr. Lawrence for Mastercard. Mr. Harris, you appear with Ms. Dimitriou and Ms. Wakefield for the Respondent. And we have a contribution from Mr. Tristan Jones for intervener, which, no, okay, right, Mr. Hoskins.
Thank you very much, my lord. Good morning, everyone. Let's remind ourselves that this is an appeal on a point of law. It concerns a judgment of the Competition Appeal Tribunal refusing Mr. Merricks permission to bring collective proceedings against Mastercard. And under section 49 of the Competition Act, appeals from such judgments are limited to points of law. So the core question in this appeal is therefore whether the tribunal committed any errors of law when refusing permission. And you're all well aware of what an error of law may comprise. In short, the tribunal has to get, there has to be no evidence to support a finding of fact made by the tribunal, or the conclusion reached by the tribunal has to be one that no reasonable tribunal could have reached, or finally, there has to be procedural unfairness. Those are the well-established categories of error of law. It's also important to bear in mind that the Competition Appeal Tribunal is a specialist tribunal. It's required by legislation to exercise its own judgment when hearing applications for CPOs, collective proceedings orders. And as you're all, again, all well aware, as Baroness Hale explained in her judgment in the AH Sudan case, the decisions of specialist tribunals should be respected unless it is quite clear themselves in law. Paragraph 30 of that judgment, and you find it at MS 1375. I don't intend to turn it up now. Let me move swiftly on to the legislative framework. And again, I'm well aware that the court will have read and looked at the legislative framework. So I just want to focus on those provisions which are particularly relevant in the appeal. First important point is that collective proceedings permit the grouping together of individual claims. If I can ask you to go to MS 1151, and that is section 47B sub 1 of the Competition Act.
Yes. Yes.
Sorry, I'm old-fashioned paper, so I'm probably slower than all of you on the electronic bundle.
It's never too late to
I know. I'm working on it. I'm working on it. Section 74B sub 1. Subject to the provisions of this Act and tribunal rules, proceedings may be brought before the tribunal combining two or more claims to which Section 47A applies. And those are to be known as collective proceedings. And Section 47A of the Act, inter alia, applies to a claim for damages which a person who has suffered loss or damage as a result of an infringement of Article 101 TFAU may make in civil proceedings in the United Kingdom. And you'll see that at MS 1149. It's section 47A, sub 1, 2, and 3. And that describes the sorts of individual claims that can be brought.
Yes.
The collective proceedings provisions of the Act therefore permit what would otherwise be individual tortious claims to be tried on a collective basis. They do not create a new cause of action. And the individual claims in the present case are for damages for breach of statutory duty. And just for reference, you see that in the claim form at paragraph 92, that's MS 323.
Yes.
Both the High Court and the Competition Appeal Tribunal have jurisdiction to hear such individual competition damages claims, but only the tribunal has jurisdiction to hear such claims on a collective basis. So Parliament has entrusted collective proceedings to a specialist tribunal, Competition Appeal Tribunal. The need for permission. Collective proceedings cannot be brought as of right. They may only be brought with the permission of the tribunal. Again, if you can go back to MS 1151, section 47B sub 4. Collective proceedings may be continued only if the tribunal makes a collective proceedings order. So 2 points from this. Parliament has entrusted the tribunal with an important gateway or filtering function. And secondly, reflecting the specialist nature of the tribunal, appeals from its decisions concerning permission are limited to points of law, which is the point I made at the outset. That is the way that Parliament has set up the filtering process. Let me turn to the provisions dealing with certification. MS 1151, section 47B sub 5. That subsection establishes two principal conditions that must be satisfied before the tribunal may make a CPO. CPO may only be made if the tribunal considers that it is just and reasonable for the applicant to act as the class representative, and secondly, in respect of claims which are eligible for inclusion in collective proceedings. And as you're all aware, this appeal concerns the eligibility condition. So let's turn to that, the eligibility condition. MS 1152, section 47B sub 6. Subsection 6 provides that claims are eligible for inclusion in collective proceedings only if the tribunal considers that they satisfy two cumulative conditions. The words "only if the tribunal considers that" confirm that matters of judgment are entrusted to the tribunal as a specialist body. And the tribunal must be satisfied of two things. It must be satisfied that the individual claims raise the same, similar, or related issues of fact or law, which is sometimes referred to as the common issues requirement, and also that the individual claims are suitable to be brought in collective proceedings. Important to bear in mind that commonality or common issues and suitability are distinct requirements, and both have to be fulfilled. Because one sees sometimes in the applicant's, by which I mean Mr. Merricks' written case, that sometimes there is a confusion of those two elements, but they are distinct requirements under the Act. And this appeal is concerned not with the commonality requirement, but with the suitability requirement. Can you go next, please, to MS 1182, which is in the Competition Appeal Tribunal Rules 2015. It's Rule 79 sub 1. The tribunal may certify claims as eligible for inclusion in collective proceedings where, having regard to all the circumstances, it is satisfied by the proposed class representative that the claims sought to be included in the collective proceedings are brought on behalf of an identifiable class of persons, raise common issues, and are suitable to be brought in collective proceedings. Now, what's clear from the wording satisfied by the proposed class representative is that the burden of satisfying the tribunal that the conditions are satisfied lies on the applicant for the CPO. The applicant must bring sufficient evidence before the tribunal to satisfy the tribunal, that the claims are suitable to be brought in collective proceedings. And if the applicant fails to discharge that burden, the tribunal does not have power to grant a CPO. These are preconditions for the tribunal may even consider whether it wishes to make a CPO. It has to be satisfied on the evidence brought by the applicant that these conditions are satisfied. Let's look in more detail at the suitability requirement. Still on MS 1182, this time looking at Rule 79 sub 2. Rule 79 sub 2 further defines the nature of the suitability requirement. First point to note is that whilst it does list certain considerations to be taken into account, it expressly states that the tribunal shall take into account all matters it thinks fit. So a very wide discretion for the tribunal in considering suitability. The second point is that Rule 79 sub 2 sub F indicates that one of the specific matters to be taken into account is whether the claims are suitable for an aggregate award of damages. And that is the particular consideration that the first ground of this appeal is concerned with. Now, in the bundles, there are, as you will have seen, various references to pre-legislative materials. And I think it's fair to say that probably none of them would satisfy the pepper and heart test. And I'm sure you're plagued by such references in most of the appeals you heard. But in our submission, you don't... I'm sure. But I'm not going to sort of push that line that you're well used to fending off, because our submission is you don't need to refer to such extraneous sources to discern the purpose of the legislation here. The purpose of the legislation is clear from its face and from the provisions we've just looked at. First of all, it's clear that the purpose of the legislation is to facilitate the bringing of collective claims. That's obvious. But secondly, not all such claims can be brought. The adoption of a specific set of certification rules and criteria shows that Parliament intended that the tribunal would exercise an important filter. By having those conditions, the legislation necessarily envisages that some applications for CPO will fail. And the final point is what I've touched on already. The filtering power is given by legislation to a specialist tribunal. The appeal from the tribunal is limited to a point of law. So it's clear again that Parliament intended that the tribunal should, if you like, be lord of this realm unless it made a genuine error of law. But matters of judgment are for the tribunal under this legislative scheme. Let me turn next to the provisions dealing with the, oh, sorry, there's a question.
Just before you move on, Mr. Hoskins, can I ask you, the tribunal seems to have approached point F, the aggregate award of damages, as though this was a necessary condition that has to be satisfied. But when you read this clause, or Rule 79.2, it looks as though there's a number of factors that ought all to be evaluated. We don't seem to see in the tribunal's judgment any discussion of the other factors.
I think it's correct that the tribunal has, under Rule 79.2, a wide discretion. And I think it's also correct that in this case, the first reason why the tribunal declined to grant the application was because the claims were not suitable for an award of aggregate damages. And I think it's also fair to say that the tribunal thought that because this application was not suitable for aggregate damages, exercising its judgment under 79.2, the tribunal found that that was a sufficient reason not to grant permission. So I agree with my Lord's observation. I think that is the way the tribunal approached the question in this case. But in my submission, it's possible for one of the criteria in 79.2F, if it is not met, for the tribunal to rely on that as a reason not to grant the application. It's permitted to do that under the legislation.
Should we take it that they were satisfied that the other factors were met? For example, an appropriate means for the fair and efficient resolution of the common issues?
Again, I think that's probably fair because it didn't find that any of the others were not met. It focused on suitability for aggregate damages and found that that wasn't met and decided, therefore, despite the other characteristics of the application, it was not going to grant permission.
Thank you.
Can I turn now to the provisions? I'm sorry.
My Lord's point may be, if they fail to material factors, is it conscious of those as evidence?
I think we're getting into probably mind reading with respect into what the tribunal did. I can't speculate as to what the subjective mindset of the tribunal was. What's clear from the face is the point I've made, which is that the tribunal thought that the 79 sub 2 sub F point was, in its judgment, fatal to the application. And it's fair to say that before the tribunal, neither Mastercard nor Mr. Merricks was focusing on the other items. There was a set of pleadings, and that is the focus in the argument became whether F was satisfied or not. The tribunal found that F was not satisfied, and then further found that exercising its judgment, it felt that the application should be dismissed.
Yes.
I turn next to the provisions that deal with the aggregate award of damages in the Act. Turn please to MS 1154. Section 47C sub 2. The tribunal may make an award of damages, quote, without undertaking an assessment of the amount of damages recoverable in respect to the claim of each represented person. And if you go to MS 1177, Again, this is in the tribunal rules. Rule 73 sub 2, you'll see, defines that award of damages as an aggregate award of damages. And then next to MS 1179, Rule 75 3 sub I sub 1. You'll see at the top of the page of 1179, the collective proceedings claim form shall contain, and then at I, the relief sought in the proceedings, including, where applicable, an estimate of the amount claimed in damages, including whether an aggregate award of damages is sought, supported by an explanation of how that amount has been calculated, i.e. the aggregate amount of damages. And then turning next to the Tribunal's Guide to Proceedings, which I should explain has the status of a practice direction pursuant to Rule 115 sub 3 of the Tribunal Rules. If you could turn please to page 1162 of the guide, MS 1162. Paragraph 613. The proposed class representative should send with the collective proceedings claim form any evidence relied on in support of the application for a CPO. That may include, for example, an expert's report regarding the way in which the common issues identified in the claim form may suitably be determined on a collective basis. And here, as you know, the applicant suggested aggregate damages as the means to determine the common issues. That was the proposal put forward. And in our submission, this part of the guidance, i.e. the need to put forward any evidence relied on in support of the application, is consistent with the fact that under the legislation, the onus is on the applicant to produce the evidence necessary to satisfy the tribunal that the statutory criteria are fulfilled. If an applicant fails to produce sufficient or satisfactory evidence, its application must be refused. It should be borne in mind at this stage that whilst collective proceedings may be brought on behalf of consumers, they are put together by lawyers and funders on a commercial basis in order to make money for themselves. And that is not a criticism of such lawyers and funders. The legislation expressly creates that commercial incentive precisely in order to encourage the bringing of collective claims on the part of consumers. But what that does mean is that when an application is brought which does not meet the statutory criteria, it should be refused. The legislation does not provide that some sort of benefit of the doubt should be accorded to poorly put together applications just because those applications seek permission to act in the name of consumers. And you'll have seen a strong flavour of that in the applicant submissions, but one should not be led down that path and away from objective interpretation of the legislation. Now, the final piece of the legislative puzzle I need to come to relates to the distribution to individual members of the class, but I'll come to that when I deal with the second issue in the appeal so that it's fresh in our minds when we come to it. So what I wish to do now is very briefly to outline the Mastercard system, which, as my Lord Kerr indicated, Lord Sales is now an expert in, but the rest of you may be happily less familiar, but I'll just take it very briefly. Mastercard operates what is called a four-party payment system. The four parties are the cardholder, the cardholder's issuing bank, the merchant, and the merchant's acquiring bank. And the way that the system operates is as follows. An issuing bank issues a debit or credit card to the cardholder. An acquiring bank contracts with a merchant to process card payments for it. When the cardholder pays at the merchant with a Mastercard card, the acquirer obtains payment for the merchant from the issuer. In the absence of a bilateral agreement between the particular issuer and acquirer, the Mastercard scheme rules provide that a multilateral interchange fee, or a MIF for short, should apply as a fallback. And the issuer deducts the MIF from the payment made to the acquirer to cover the issuer's costs. And the sum that the merchant receives from its acquiring bank also does not include the MIF. So the merchant receives less than the sum of the item or service purchased by the consumer. There are different types of MIF. For example, there is an intra-EEA MIF, which applies where a card issued in one EE state is used to make a payment in a different EEA state. There are domestic MIFs, which apply where a card issued in one state is used to make a payment in that same state. But there are also different types of intra-EEA MIF and domestic MIFs. There are different MIFs for debit and credit cards. And then there are subdivisions. For example, there's a different MIF for chip and PIN payment. So there is a series of different types of MIF. On the 19th of December 2007, the European Commission adopted a decision which found that Mastercard's intra-EEA MIF infringed Article 101(1) in the period from the 22nd of May 1992 until the 19th of December 2007. And it is that decision which forms the basis of the application which we have before us. Let me turn to then the application that was made for a CPO. First of all, the basis of the individual claims that were sought to be combined. The applicant, Mr. Merricks, sought permission from the tribunal to continue collective proceedings for individual claims based on the Commission decision. And the individual claims for breach of statutory duty were said to arise in the following way. And I'm here summarising paragraphs 4 and 25 of the tribunal judgment, MS 239 and 246, but I'm not asking you to turn that up. So this is the way Mr. Merricks puts the individual claims. If it had not been for the infringement of EU law found in the Commission decision, the intra-EEA MIFs would have been set at a lower level than had in fact been the case. Second, if the level of the intra-EEA MIFs had been lower, this would also have caused the domestic UK MIFs to be lower. And the value of the claim is in excess of 90% relates to the domestic MIFs. And I should say there is very fiercely contested by Mastercard, that causation issue, but that issue is for another day. The third point is that Mr. Merricks says that the infringement of EU law found by the Commission therefore led to what's called an overcharge. That is the difference between the actual levels of the relevant MIFs and the levels that would have been set in the absence of the infringement. That difference is referred to as the overcharge. It's then said that issuing banks deducted the amount of the MIF from the sum paid to acquiring banks. It's not in dispute. The acquiring banks deducted the amount of the MIF from the sum that they paid to merchants. And the acquiring banks therefore passed on the overcharge element in the MIF to merchants. And again, there is no dispute about that in this appeal. Where one does get to the nub of the dispute, particularly for this appeal, is the next stage, because Mr. Merricks then says that the overcharge caused merchants to charge higher retail prices across the board to all of their customers than otherwise would have been the case. And it said that it therefore follows that all customers who made purchases from merchants who accepted Mastercard cards, regardless of whether they used a Mastercard card to make payment or not, suffered loss as a result of the higher retail prices they were required to pay. So that, I hope, does justice to the nature of the claim. And Mr. Harris and Mr. Dimitri will correct me when their turn comes if I've got that wrong or missed something. Let's look next at the class definition in the claim form. That's MS64. So, I'm sorry, this is actually taken from the Statement of Facts and Issues, paragraph 2. So you'll see in italics, there's a definition of the class at paragraph 2. And then you'll see commentary that follows. The size of the class is estimated to be around 46.2 million people. In other words, the applicant was seeking permission to combine around 46.2 million individual claims. The claim period was from 1992 to 2008. That is a period of 16 years, which began and ended many years ago. And the claim sought aggregate damages in excess of £14 billion. So the scale of the claim is obvious from those figures.
Mr. Hoskin, I know it's a peripheral point which we don't have to decide, but I was perplexed by the timing. Is there a limitation issue in this case?
There is. We raised a limitation point before the CPO hearing, and it was agreed that if certification was granted, then it would be dealt with after certification.
Okay.
I think it may have been by way of summary judgment or strikeout, it was to be dealt with, but I can't remember that exactly. But absolutely, there is a point, and it's live.
Thank you. That's all I wanted.
The tribunal refused the application on two distinct grounds, and it's important to note that either of those grounds would have required the CPO application to be dismissed because it would have failed to meet a statutory criterion. So either or would have sufficed for dismissal. First of all, the tribunal found that the claims were not suitable for an aggregate award of damages under Rule 79(2)(f) of the tribunal rules, and that's the first issue in this appeal. And secondly, the tribunal found that the claims were not suitable to be brought in collective proceedings as required by Section 47B sub 6 of the Competition Act, because it was impossible to see a distribution of an aggregate damages award to individual members of the class could be determined on any reasonable basis. And I'll obviously come in detail to look at those parts of the tribunal's judgment. And both these grounds of refusal were overturned by the Court of Appeal. Now, because each of the tribunal's grounds required rejection of the application, because it meant the relevant statutory criteria were not met, it follows that if Mastercard is successful on either of its grounds of appeal, then the tribunal's order refusing the application should be reinstated by this court. I only need to win on one of the issues in order for the tribunal's finding to become valid. That's all I wanted to say in terms of the introduction and setting the scene. And so I will now turn to deal with the first issue in the appeal. The first issue for this court is whether the tribunal committed any error of law when it decided that the claims were not suitable for an aggregate award of damages. And obviously, Mastercard's submission is that the tribunal's conclusion and reasoning were entirely consistent with the applicable legislation. Let's look at the applicant's proposed approach to aggregate damages. The applicant sought an aggregate damages award on behalf of the class as a whole. And the methodology that he proposed to use to calculate the aggregate damages was set out in a joint expert report from Dr. Velyanovsky, an economist, and Mr. Dearman, an accountant. And if you could please go to that expert report and pick it up at MS 512.
Yes.
So this is the joint expert report, and I'd like to begin considering it at page 531, section 5. You'll see the heading Aggregate Award of Damages. The methodology proposed by the experts incorporated the following steps. First of all, at MS 532, paragraph 5.2.3. The expert said our starting point, therefore, is to consider all payments made by consumers using a Mastercard issued card to businesses selling goods and/or services in the United Kingdom during the full infringement period. So the first step was to calculate the total value of payments made by consumers using a Mastercard card to merchants selling goods and/or services in the United Kingdom during the infringement period. And that, as you'll see from the heading at 5.2, is referred to as the volume of commerce, or VOC. If we go next to 537, MS 537, paragraph 5.3.17, the overcharge will be calculated by comparing the average actual and estimated values for Mastercard MIFs during the infringement period based on actual data with the average counterfactual interchange fee based on a fully developed methodology along the lines of those discussed above. So the next stage was to calculate the overcharge. That is the difference between the level of the MIFs actually set and the level that those MIFs would have been set at in the absence of the infringement. The next stage is at MS 539, paragraph 5.4.1. See the heading, the MIF pass on. It is our expert opinion, based on the available evidence, that the MIF was passed on by acquirers to businesses, merchants. So this is the first stage of the pass on. You see it is assumed that the MIFs, and therefore the overcharge, was passed on in full by acquiring banks to merchants. And as I've previously said, that is not in dispute for the purposes of this appeal. And then at 542, paragraph 6.1.1, see the heading, the MSC pass on, 6.1.1, the extent to which the MSC, that's the merchant service charge which incorporated the MIF, was passed on through increased retail prices charged by businesses to consumers is more complex than MIF pass on and will require further investigation and analysis. We accept that MSC pass on is a matter for further evidence and analysis, and that different views have been expressed in recent legal proceedings. So this is the crucial part of the methodology for the purposes of the appeal. This is dealing with calculating the extent to which the overcharge was passed on by merchants to consumers. And the reason why this is the crucial part of the methodology for this appeal is because the applicant failed to satisfy the tribunal that the data required to carry out this part of the methodology would be available at trial. Let's pause for a moment and ask, why is this part of the methodology so problematic? The approach suggested by the applicant would require calculation on an aggregate basis of the extent to which all merchants in the United Kingdom who accepted Mastercard cards passed on any overcharge to their customers by way of higher retail prices. And that exercise would have to take place in the context of the following factual situation. In 1992, at the start of the claim period, there were about 500,000 retailers in the United Kingdom accepting payment by Mastercard cards. And that was at the start of the claim period. But that had risen to some 800,000 merchants by the end of the claim period in 2008. I'll just give you the reference for those figures. I'm not going to turn them up. That's Tribunal Judgment, paragraph 50, MS 256. In their oral evidence to the tribunal, the experts accepted that, first of all, there was likely to be significant variation in the extent to which merchants in different sectors of the economy, for example, the food and drink sector, as compared to the motoring sector or the financial services sector, passed on any overcharge to their customers by way of higher retail prices. So different rates of pass on as between sectors. And the reference for that, Tribunal Judgment, paragraph 63. Sorry, there's a question. I'll finish the reference, then I'll stop. MS 261.
I think my microphone is on. Mr. Hoskin, just before we get into the granular detail, you say this is all higher prices, and the use of higher assumes that price X is higher than price Y. Is price Y the price which would have been charged on a counterfactual if? Or is it some price higher than was charged before somebody started using a Mastercard? In other words, are we in a semi-counterfactual world, comparing the real world with the counterfactual world, or just two different aspects of the real world?
You are comparing the actual MIFs charged with the interchange fees that could lawfully have been charged.
So the higher means real world higher than counterfactual world.
Absolutely.
Thank you.
So I was dealing with the oral evidence of the experts. They accepted there was likely to be significant variation between sectors of the economy, but they also accepted that within each broad sector of the economy, so food and drink, motoring, etc., that there is a wide variety of businesses, and that they them in turn may have significantly different rates of downstream pass on. So for example, the motoring sector covers fuel, new vehicle sales, car rental, garage repair services. The businesses are very different. The markets in which the businesses operate are very different. It's likely that those sorts of businesses will have different pass-on rates in terms of the prices that they charge their customers. Another example, in the food and drink sector, any pass-on by major supermarket chains may be significantly different from the rate of the corner shop or the local butcher. And the reference for that is Tribunal Judgment, paragraphs 42 and 63. That's MS 252 and 261. A further difficulty with this proposed exercise is that rates of pass-on may also vary geographically across the United Kingdom. That's Tribunal Judgment, paragraph 42, MS 252. And finally, the pass-on rates may also have varied over time. That's Expert Report, paragraph 6.2.1 at MS 542. And Tribunal Judgment, paragraph 50, MS 256. So I hope it becomes immediately obvious the difficulty in the nature of this task in assessing the rate of merchant pass-through for the whole economy over that extended period of time, ending in 2008. There are all sorts of complexities bound up in that process. So how did the experts, I'm sorry, another question.
So just one other question to make sure I fully understand. This is all built presumably on a set of counterfactual lawful if rates, which would not necessarily themselves have been constant over time, although I suppose there wouldn't have been much geographical change or differences between different banks, but tell me if I'm wrong.
That's correct. Comparison would have to be with the actual MIF rates. So in certain of the trials that took place brought by retailers, an average was taken across the actual myths. So I don't want to present that as a difficulty that hasn't been overcome in other contexts.
Right.
An average was used.
Thank you.
So we're looking at how the experts said that they would deal with these problems or address these problems. If we're still on MS 542 in the expert report, can I ask you to just refresh your memories by looking again at paragraph 6.2.3 A and B? You will see, first of all, that there are various types of potential evidence referred to, and I'll come back to address that. You'll see in 6.2.3b, second sentence statement, assuming the MSC pass-on rate is consistent across businesses operating in the same sector, which we consider is a reasonable economic assumption at this preliminary stage. And then a methodology is put if that is in fact the case. But that assumption was not reasonable. And one sees that in tribunal judgment, paragraph 63, that's at MS 261. You'll see at the top of page 261, second sentence, as regards pass-through, the experts in their oral evidence accepted that there is likely to be significant variation, not only as between different kinds of goods and services, but also different kinds of retail outlet. So what was said to be a reasonable economic assumption in the expert report was not maintained by the experts in the tribunal. If we can go back to MS 542 and pick it up over the page at 543, so the end of the passage I asked you to reread, you'll see sentence, this covers approximately 70% of all payments processed with a card in the United Kingdom. See Appendix 3. And Appendix 3 is at MS 565. And this is where you'll see the breakdown by the experts of the United Kingdom economy into 11 sectors. So first of all, there are two broad headings, retail sales and services. And then within, for example, retail sales, which is effectively goods, one has the categories food and drink.
Where are you reading from, please?
I'm at MS 565, my lord.
Yes.
Should be a table.
Retail sales, yes, yes, I've seen that now. Thank you.
So you've got goods and services. Then under goods, you've got various sectors, food and drink, mixed business, etc. There is a catch-all category under goods of other retailers, which is the second largest category for goods, called other retailers, which is just everything else not covered by the big headings. Then similarly in relation to services, a number of headings, and then other services, again 11%, again the second largest, the catch-all in the services sector. So when we're talking about the sectors of the economy, it's coming from the applicants' experts' proposed methodology. This is how they intended to view the UK economy. Once the experts accepted that pass-on rates were likely to have varied significantly across the different sectors, the paragraph 6.2.3 methodology fell away, and therefore one had to move to the methodology at 6.2.4, which is at MS 543. You see it begins, if MSC pass-on rates are ultimately found to be significantly different for different sectors of the United Kingdom economy, which is what the experts accepted before the tribunal, then we may be able to calculate a weighted average MSC pass-on rate, weighted by reference to the VOC and pass-on rate associated with each sector during each year of the infringement period. This approach will depend on the availability of evidence and whether that evidence relates to the same period as the full infringement period. There's a lot in that. Let's break that down. First of all, the experts say we may be able to calculate, not we will be able to calculate. There is a certain hesitation on their own part on whether this complex task is going to be achievable. Secondly, the average pass-on rate would be weighted by reference to the pass-on rate associated with each sector. Therefore, according to the applicant's own experts, it would be necessary to have sufficient evidence to calculate the pass-on rate associated with each sector of the UK economy. The third point, the words during each year of the infringement period. It would therefore be necessary, according to the experts, to have sufficient evidence to calculate the pass-on rate associated with each sector of the UK economy during each of the 16 years of the infringement period. And that's because the pass-on rates may have varied over time. And finally, the experts explained to the tribunal that this approach would depend on, 1, the availability of evidence, and 2, whether that evidence related to the same period as the claim period. This is what the experts, the applicant's experts, are telling the tribunal. If we can go next to paragraph 6. I'm sorry.
I'm sorry. There's nothing unusual. There's nothing unusual in an expert giving at an early stage will obviously have to refer to the possibility of evidence sustaining propositions may be underpin the claim. These are expressed in tentative or provisional, but it doesn't mean to claim, does it?
Not in itself, no, absolutely, my lord. I absolutely accept that, and I'll come on to deal with in more detail. At the certification stage, it's certainly not the case that the expert has to come on with a fully formed methodology and all the evidence collected. We'll come into the nitty-gritty, but absolutely, at the certification stage, what is required, as we'll see, is that the expert comes along and says there is a plausible methodology and there is some evidence that the data I need to operate that methodology will be available. But absolutely, my lord, I accept, and we're in the same place on that point.
The expert is surely not saying in that
Sure we will.
In that last sentence, he's not, I think, saying, is he, if, for example, we have a year's gap, then the whole process crashes either for that year or generally. I mean, talking about depending on availability and whether it relates to the same period is all about extrapolation and making due allowance for sensitivity and the weight of evidence if there's a time gap, the sort of thing which, for example, property valuers and rental valuers do almost daily.
I completely, again, I completely agree, my lord. I'm simply showing you at the moment what the experts said they would need to do their methodology, and I'm not suggesting that they were saying you would need to have every single stone unturned for every year, but clearly you would have to have sufficient confidence that the stones were there and you could identify them and overturn them. But this is not an exercise in perfection. That's not what I'm saying these experts were suggesting. We'll come to it. I'll show you it's not what the tribunal was demanding either.
Thank you.
Thank you. If we can go to, oh, I'm sorry, is there? Happy to move on. Paragraph 6.3.1 on MS 543. At this preliminary stage, prior to disclosure and exchange of witness evidence, our starting position is that during the full infringement period, it is likely that there was full pass-on of the MIF, including the overcharge to members of the proposed class. We rely on the following statements and findings. And what the report then refers to are various snippets of evidence, and I use the word snippets, we'll come and see them because that's really what they are, in support of that stated position. In relation to the starting position, I'm sorry, my lord.
I'm sorry. That it was likely that to members of the proposed class. Preliminary to the obtaining of disclosure and exchange of evidence. I mean, already they were concluded that there was. Is that right?
That is the preliminary conclusion that they were expressing in the report, my lord, absolutely. And the problem was that even as a preliminary conclusion, that position was unsustainable, even on a preliminary basis. If you can go to the tribunal judgment, MS 265, paragraph 76. Overall, we recognise that the methodology put forward by the experts in their oral evidence in response to the tribunal's questioning is considerably more sophisticated and nuanced than that set out rather briefly in their experts' report. We have to say that it is unfortunate that the written report did not set out and explain their approach in this way. Indeed, the statement in the report that at this preliminary stage, the expert's starting position was that it is likely that there was full pass-on of the MIF, including the overcharge to members of the proposed class, is unsustainable and was not adhered to in their oral evidence. So you'll see that the tribunal was very fully aware of the preliminary nature of the report. And what it did through its questions was it sought to actually help the experts express in more detail what their position was than had been expressed in the report. But you'll also see the second point.
Is there it was unsustainable and not shared in the oral evidence?
Well, it comes from the transcript. It's not, again, this is not disputed. The question was put, questions were put by the tribunal, and that was the position. If the court wishes, we can obviously give you the transcript references, but that's not in dispute between the parties, that position was not adhered to. That was the position in the report, not adhered to before the tribunal.
If it's not in dispute, let's not waste time on it. Right. Certainly. Okay, we know then.
So we're going to look at the snippets of evidence which were put forward in the report as being the evidence that would allow the methodology to be operated. And our submission is that these snippets do not even begin to meet the criteria that the experts themselves said would have to be met, i.e. evidence that would indicate the level of pass-on in each of the 11 sectors of the United Kingdom economy for each year of the infringement. And when I use the words each year of the infringement, I take Lord Briggs's point and we can understand them on the basis that Lord Briggs put it to me. But that is what the experts themselves said they would need for their methodology. We'll go back to the report at MS 543.
Sorry, Mr. Hoskins,
yes, my lord.
I'm just a little bit unclear why this matters so much. I mean, isn't it clear that if this collective action to trial, it will be a significant issue at trial, one of the most significant issues at trial, what level of pass on there was to consumers. So I'm not quite sure why you're putting such emphasis on the inability of the experts to give a definitive answer on that in their report. Wouldn't it be sufficient for them to map out a methodology which was capable of showing that there was some level of pass on, that level to be argued over at trial?
Well, we'll come to what the legal requirement was. So you'll excuse me, what I'm doing at the moment is just showing you what the experts themselves said. And then I'm going to come on in my submissions to the approach adopted by the tribunal, which came from the Canadian case of Process and Microsoft. And then we will address then what the correct legal approach. But what I need to do first, if you'll bear with me, is simply to set out what the experts were saying. And I anticipate, or accept rather than doing that, I'm anticipating the arguments I will make, but I will come to those arguments. But the short point is, just so you know where I'm going and why I'm doing this, is that it was stated by the tribunal, relying on Process and Microsoft, that the experts, in order for the certification criteria to be met, had to show that they had a plausible methodology and had to produce some evidence that the data necessary to operate the methodology would be available. And the Court of Appeal, as we'll see, also said that was an appropriate question to ask at the certification stage. So the reason why we're looking at what evidence the experts identified as being the evidence that could operate their methodology is because of that legal test that both the tribunal and the Court of Appeal accepted was an appropriate question to ask at the certification stage. I hope that sort of anticipates where I'm going.
Yes, well, up to a point. But just so you know what I have in mind, I mean, I do remember from the Sainsbury's hearing where you, Mr. Hoskins, were arguing the broad axe point and were emphasising that the Mastercard and Visa would, in certain cases, wish themselves to be arguing that there had been pass-through from the retailers to consumers, and there was some debate about, you know, the evidence that would be relied on for that. I mean, that evidence is going to be the same as the evidence that the consumers would need to rely upon for their claim here. In some ways, the consumer's claim is the other side of the coin of the Mastercard and Visa's pass-on defence as against the retailers, isn't it?
That is correct. And again, I'll come on to deal expressly with this. But again, at the moment, as my lord, you're aware, the only of the supermarket cases that has gone to trial on pass-on was the Sainsbury's case in the tribunal, and the tribunal found there was no pass-on to consumers.
And that's because your evidence wasn't good enough to show that. But you, in your submissions to us, were saying in other cases there will be evidence that is good enough for Mastercard and Visa to show that. And what's perplexing me a little bit is, if that's right, if Mastercard and Visa are saying in some cases there will be evidence good enough to show pass-through, why isn't that supportive of the idea that for the consumer's claims there will be evidence to show pass-through?
Because the nature of the exercise in an individual claim brought by, for example, a supermarket against Mastercard is of a completely different order of magnitude from what is suggested here, which is an assessment of the rate of pass-on for every business in the United Kingdom that accepts Mastercards, and that over a 16-year period, and that against a backdrop of the fact that pass-on rates may vary geographically, that against the backdrop that the rates may vary over time. The order of magnitude of the exercise being suggested in this case is exponentially bigger than anything, my lord, that would arise in an individual claim by a supermarket against Mastercard. It's an economy-wide exercise that's being suggested. That's an incredibly important difference. When one is asking, is this a methodology which can be carried out in practice? It's against that factual context that that question has to be answered.
Yes, thank you.
In the expert report at paragraph 6.3.2, on page 543, and we come to the point that Lord Sales effectively just put to me, which is the Sainsbury's and Mastercard's case in the tribunal, and what Mastercard had pleaded in that case. So this was a case brought by Sainsbury's against Mastercard. There was a trial of, I can't remember, 6 weeks, I think it was, we were in the tribunal. And one of the issues that was dealt with was whether Sainsbury's had passed on any of the overcharge in the MIF to its customers. Now, what the report does not tell you, it refers to Mastercard's pleadings in the case at 6.3.2. But what this report does not say anywhere in it is that the tribunal actually found that Mastercard had failed to prove that Sainsbury's had passed on any of the MIF to its customers. So on one hand, you had the expert saying, we believe there was full pass on by all businesses to their customers. And in the one case it's gone to trial, the opposite was in fact found. And the omission is particularly surprising, given that the tribunal delivered its Sainsbury's judgment on the 14th of July 2016, and the expert report is dated September 2016. Was, and still is, the only case against Mastercard, or indeed Visa, to have considered and determined the issue of pass-on of the MIF to consumers. If we can go on to page 544, MS 544, paragraph 6.3.3, the expert reports here refers to certain short quotes from competition authorities and regulators. And what's important to note when one looks at these quotes is while they make general comments about the likelihood that the MIF will be passed on to consumers by retailers, none of the quotes provide or refer to empirical evidence about the levels of pass-on of MIF to consumers. Because as I showed you, for the experts' own methodology, they explain that for the weighted average approach, they will need to have evidence of the rate of pass-on for each of the sectors. It's not enough that there simply was some pass-on. They will need to come up with the weighted average evidence on the level of pass-on. And I'm not going to read out all these quotes. It becomes very obvious when you quickly read through them the point I'm making, but let's take the first one, the EC decision. The European Retail Roundtable, a group representing the interests of large retailers in Europe, stated at their oral hearing that interchange fees inflated the costs of accepting payment cards, in particular for its members, large retailers, and that those price increases would ultimately be passed on to the final consumer. So that's just recounting evidence from the European Retail Roundtable. Next, a further consequence of this restriction of price competition is that customers making purchases at merchants who accept payment cards are likely to have to bear some part of the cost of Mastercard's MIF, irrespective of the form of payment the customers use. These are very high-level statements about the likelihood of pass-on to consumers. And I should make it clear that the decision does not contain any detailed findings on pass-on to consumers. It has these sorts of general statements occasionally, but it does not determine levels of pass-on to consumers. And there's then over the page at 545, similar type quotes, and you'll see that the experts themselves don't put much stock in these quotes. At the top of MS 546 at 6.3.4, we accept that these statements alone are not conclusive evidence of MSC pass-on, but they reflect specialized competition bodies and industry regulators' conclusions that the MSC is generally passed on through higher retail prices. But the experts themselves don't suggest that these snippets give any evidence of the levels of retail pass-on in each of the sectors, or indeed any of the sectors of the United Kingdom economy. The next snippet is 6.3.5, an article in the Daily Telegraph. With respect, that really takes matters no further. I'll let you briefly look at that. Paragraph 6.3.6 and 6.3.7. There is a large body of empirical evidence on pass-on of input costs, such as sales taxes, foreign exchange fluctuations, interest rates, merger cost economies, etc. This empirical evidence, as one would expect, shows a variety of cost pass-on rates, ranging from low to many orders of magnitude of the cost increase. And then as footnote 49, see the extensive survey of pass-on theory and empirical studies, cost pass-through, theory measurement, etc., a report prepared for the Office of Fair Trading, February 2014. And as we'll come on to, and I'll show you, that is the RBB report refers to in its judgment. And then 6.3.7, whilst these studies show that pass-through of cost increases is unlikely to be small or zero, we do acknowledge that they relate to different types of cost increases, products, sectors, and countries than those covered by the proposed collective proceedings. So the experts are saying, well, insofar as there are those reports referred to in the RBB report, we accept that they're not necessarily going to be that helpful. It is therefore more appropriate, in our opinion, to rely on studies that relate to retail markets in the United Kingdom. Then 6.3.8 and 6.3.9. When we look specifically at United Kingdom retail markets, the evidence from similar cost increases suggests that a high MSC pass-on rate is likely to be the case. So finally, we're getting into what actually matters. We're starting to look at the levels of pass-on in the UK economy. For example, studies show that the 2.5 increase in VAT, cost increase not dissimilar to the credit card MSC in January 2011, was fully passed on by United Kingdom businesses in particular. But then one sees that they're not in fact saying that there has been an empirical study and the level of the pass-on has been established in relation to the VAT increase. First of all, the Bank of England's monthly survey of retailers for September 2010 reported that the majority of retailers expected to pass on the 2.5 VAT increase in 2011. And in January 2011, the BOE inferred a pass-on rate of 90%. B, the Centre for Retail Research publication, How Soon Will Prices Go Up, reported that 64% of retailers surveyed would pass on most or the full amount of the VAT rise in the first month, and that 98% of retailers would ultimately pass on the whole of the VAT increase to customers. So this is dealing with VAT, not the MIF, and the evidence which is cited is not empirical studies of actual pass-on rates, but simply reports intentions, future intentions stated to the BOE and the Centre for Retail Research. Paragraph 6.3.10 and 6.3.11. I'm sorry, Lord Sales.
Yeah, sorry, Hoskins. Again, I'm just not quite sure of the significance of the point that you're making. I mean, the increase in the MSC represented by the inflated MIF is a cost for the retailers and the service providers. And it's going to be obvious that if they can pass it on, given the markets in which they operate, they will pass that on in order to maximize their profits. Now, I appreciate there are many different markets and many different constraints under which they are operating. But the likelihood that they will seek to pass on, and in some cases will pass on, seems high, even if one can't put precise figures on it. And in relation to the particular point you're making about what's being talked about here as increases in VAT and the extent to which that is passed on, I mean, again, if I may, in the submissions in the Sainsbury's case that we heard, I think these ones were presented by Miss Rose, but you adopted them. The analogy was strongly pressed that the MIF was like VAT, and as just a cost of doing business. And so I don't myself follow why you're saying that there won't be some methodological basis for trying to estimate as best one can in the circumstances a level of pass-through, and why it's not going to be relevant to refer to pass-through of VAT increases.
Well, Lord, I'm sorry, I sort of laughed wistfully when you started to make your comment, not out of disrespect, but because I wished you had been, I wished you'd been the chair of the tribunal in the Sainsbury's and Mastercard judgment, because you're absolutely right that in that case, one of the pieces of evidence that Mastercard deployed was evidence relating to how businesses dealt with VAT increases. What we also submitted was that in a competitive market, as my lord you just said, one would expect such cost increases to be passed on, and indeed you would expect the majority of them to be passed on. That was part of the evidence and the submission that we made to the tribunal in Sainsbury's.
So your own case is that there is a methodology for working these things through.
Well, my lord, no, because what one can do in an individual case against a single retailer is one can go through a very great deal of evidence, which we did in that case. We had economic theory, we had some econometric studies, we had some evidence in relation to VAT. And the tribunal went through that, and it was a very complicated process. Now take that, that's a claim by one retailer, and multiply it by 500,000. That's for the beginning of this period. Or multiply it by 800,000. That's the end of this period. But if one simply starts from, well, in an individual case, it is possible to do this, I accept that someone can put up a case. It may succeed, it may fail. And your point to me is it doesn't matter whether it succeeds or fails. Can you, as a matter of practicality, put forward a case of this sort? Absolutely you can. But the issue here is, can you do it when you're dealing with 500,000 to 800,000 individual retailers? And in our submission, that's practical, and that is what the tribunal found.
But why isn't the fact that you've multiplied? Oh, sorry.
I was just saying what I says.
Sorry, it was just to follow up on that. Why isn't the fact that there are lots and lots of these businesses, and that makes individualized assessment impracticable, not point in the direction of extrapolating across businesses, not going in fine granular detail, but approaching the evidential issues on a broader basis, relying on inferences and extrapolation?
Lord, again, Mastercard's case is not that Mr. Merricks has to show that he can conduct a granular exercise for 500,000 to 800,000 individual retailers. But what he did have to convince the tribunal was that there was a broader brush approach that was possible. And the methodology that was proposed by the experts was the weighted average proposal. In relation to the weighted average proposal, as I showed you, they said they would need to have evidence for the extent of retail pass-on for each sector, each of the 11 sectors in the UK economy, for each year of the infringement period. Again, applying the Lord Briggs caveat on that. So what we're not looking at, and what the tribunal was not asking, is can you do this 500,000 times? Because that clearly would be impractical and impossible. What the tribunal was evaluating was, given that you have that problem, is the methodology proposed by these experts one that is actually going to be practical? Are you even going to be able to get the evidence you need for each of the sectors for over the relevant period of the claim? And that's what the focus is on, my lord.
Thank you.
The only time one sees any evidence of the sort of nature that would go to that sort of sectoral assessment of the level of pass-on is in paragraph 6.3.10 and 6.3.11 of the expert report. Because here, the experts point out that there is some empirical evidence about the level of pass-on though not specifically MIF pass-on, but of pass-on in relation to petrol sales and supermarkets. And you'll see the reference 6.3.10a, the OFT conducts analysis of the United Kingdom petrol sector, and B, the Competition Commission had a groceries investigation. Now again, let's just put this in context for the purposes of what the experts are proposing. Petrol is just one part of the motoring sector. Supermarkets is just one part of the food and drink sector. So as I said earlier, motoring would cover car sales, garages that repair your car and carry out MOTs, petrol. Food and drink sector, you will see immediately covers a gamut of different types of businesses, not just supermarkets. The experts do not point in their report to the suggestion that similar empirical studies have been carried out for any other parts even of these two sectors. Sorry, Lord Leggett has a question.
Suppose at the end of the day, Mr. Hoskins, if these claims went forward to a trial, suppose at the end of the day, all that was established was that for petrol sales and supermarket sales, there was a pass-on. Why wouldn't that render the claim suitable for an award of aggregate damages, or an aggregate award of damages, albeit a much smaller one than is being claimed? But it would still be an award. Might be quite a large sum of money.
Well, it is possible in the context of collective actions to have subclasses or parts of claims. It was never suggested, has not been suggested by Mr. Merricks that his claim could go forward on the limited basis. And there is a practical element to this, because if, for example, at the outset, Mr. Merricks made an application and said, I'm making an application in relation to petrol and in relation to supermarkets, as you say, that might be worth quite a lot of money. And he might have made the application and said, look, and here you have the OFT and you have the Competition Commission, and I'm going to bring this claim. And that may well have got through if it was put on that basis. But the problem is that that's not the way it was put. What the actual application would require is the tribunal to conduct a full trial across all the sectors of the UK economy. And what the filtering process allows or requires the tribunal to do is to ask in advance whether it is appropriate to allow a particular case to go through or not. And the tribunal, in my submission, I'll come on to the law, etc., on what the tribunal is and isn't allowed to do. The tribunal is perfectly entitled within the law to say, this claim is so overblown, we're not going to allow it to go through. It would not be a proper use of judicial time. It would not be fair on Mastercard when the applicant cannot even at the initial stage suggest or point to the fact that the evidence is likely to be available for the scope of his claim. So absolutely, if a narrower claim had been brought, this might have got through. I'm not going to accept, you understand why, that would definitely have got through. It would have had a better chance, but one cannot dissociate these two particular items of evidence from the nature of the claim as a whole, which, as I hope I've made clear, is a completely different beast from the narrow one that might have been put. So petrol, just one part of the motoring sector. Supermarkets, just one part of the food and drink sector. There is no suggestion that empirical evidence, any sort of evidence, is available to determine the level of pass-on for the other parts of these sectors, or indeed any of the other 9 sectors. And you remember that 2 of those 9 sectors includes other goods and other services. That's 22% of the claim. And in there is a myriad of catch-all type businesses. That, in a sense, is the high point of the report in terms of the evidence that the experts themselves say they would need. Evidence of the level of retail pass-on in the sectors. This is as good as it gets, and it's only petrol and it's only supermarkets. If I can move on to page 548, paragraphs 6.3.12 and 6.3.13, pricing and economic theory. And again, you see an echo of the point that Lord Sales put to me, which is what economic theory is, that when one would expect pass-on to be high. So there is that pure theory. One sees that referred to in 6.3.13. And then footnote 57 is another reference to the RBB report, which the tribunal relied upon. You'll see footnote 57 as referred, as reviewed in RBB in the reference to the report. We've already seen the reference to.
Footnote 57, please.
It's right at the foot of MS 548.
Yes, I see it. Yes, I've got it. Thank you.
Got it.
Thank you.
Now, that was the totality of the evidence upon which the applicant relied to discharge the burden upon him to demonstrate that his claim, his broad claim, was appropriate to go forward, and that an aggregate award of damages was appropriate. And I make 2 points at this stage. Under the legislation, the burden is on the applicant to produce sufficient evidence to satisfy the tribunal that the statutory criteria is met. And secondly, the legality of the tribunal's judgment must be assessed on the evidence actually put before it. The tribunal is not required to have a crystal ball. It is simply required to assess the evidence that is put before it by the applicant. So let us now turn to, well, I was about to turn to the tribunal judgment. I see it's 11:27. I don't know if you'd like me to do 3 minutes and then break, or break now before I start a new.
Whichever suits you. Which would you prefer?
Let's break now, and then it saves me starting and stopping almost immediately, my lord.
Okay, we'll rise metaphorically for 10 minutes. Thank you.
Thank you very much.
Right, Mr. Hoskins.
Thank you, my lord. I think one of the purposes of the short break was to take instructions, or for solicitors to tell me if anything I'd said had horrified them. One item that fell into that category I'd like to clarify, which is in response to a question that Lord Leggett asked me in relation to Rule 79.2 and all the various criteria, which includes whether suitable for aggregate damages. And my solicitors just asked me to make clear that we're not conceding that the tribunal found that all the others were fulfilled, but clearly you have my submission that they were refusing protection on 79.2F.
Sorry, we lost you a moment there.
Oh, see, I'm sorry. That's not good. Let's see if that helps.
Yes,
so
that's better.
We're not conceding that the tribunal positively found that all of the other criteria were fulfilled. But you do have my submission that the reason why, the first reason why the tribunal refused to grant to the CPO was because of the failure to satisfy them that this was suitable for an award of aggregate damages. It's just I want to make clear there's no concession on the other criteria.
Right.
I'm turning now to the tribunal judgment. If we can go to MS 258. This is where the tribunal's analysis at this point begins. It's the introductory paragraph to the tribunal's analysis. You may just want to quickly refresh your memory. I'm sure you will all have read this.
Sorry, 258.
MS 258, and it's paragraph 57 of the tribunal's judgment.
Yes, thank you.
It's the introductory part of the analysis. Now, first of all, the tribunal says straight up front, an application for CPO is not a mini trial. And the applicant does not have to establish his case in anything like the same way that he would at trial. However, the applicant has to do more than simply show that he has an arguable case on the pleadings, as if, for example, he was facing an application to strike out. Collective proceedings on an opt-out basis can bring great benefits if successful for the class members, which those individuals or small businesses otherwise could never achieve. But like almost all substantial competition damages claims, they can be very burdensome and expensive for defendants. And that sort of echoes my response to Lord Legate's last question about why the fact that some of this might have a grain in it of a valid collective action in it somewhere doesn't mean that the whole thing should be allowed to go forward. And going on, the tribunal says the eligibility conditions are set out in section 47b sub 6 of the Competition Act and adumbrated in the CAT rules, require the tribunal to scrutinise an application for CPO with particular care to ensure that only appropriate cases go forward. Now, the statement that the applicant has to do more than simply show that he has an arguable case on the pleadings, as if, for example, he was facing an application to strike out, in our submission is clearly correct. Because as we've seen this morning, as you're aware, the certification procedure laid down in the Act and the tribunal rules is a multifaceted filtering process. It requires consideration of a large number of issues. There are those that are specifically identified in Rule 79 sub 2, but also, as I showed you, Rule 79 sub 2 allows the tribunal to take account of all matters that it thinks fit. So all the tribunal is saying
between the two statements that he has to do more than show that he is an arguable case and that it's not a mini trial. How do you articulate the rubric that should portray the test to be applied?
I'm only hesitating because obviously I'm going to have to come on to that. I'm going to come on to it very shortly. If you'll bear with me, can I answer that question in literally about 2 minutes' time, my lord?
By all means. I mean, if you were inclined to give us a sneak preview, that would be good. But don't feel obliged to do that.
I just think it'll be clumsy. I've got a very short point to make, and then I'm coming.
All right,
coming literally on to your to the roadmap you want from me. I promise. I promise.
We can eagerly await.
Indeed, a bit of suspense on live television. Why not?
Yeah.
The relevant factors which one finds in Rule 79 sub 2 are also different in character from a strikeout. The strikeout obviously concerns the merits of a pleaded claim, but 79 sub 2 is looking at different issues. It's about whether it's appropriate for individual claims to be brought on a collective basis. That's what Rule 79 sub 2 is about. And indeed, there is a specific power to strike out a claim, including in collective proceedings, in Rule 41 sub 1 sub B of the tribunal rules. I don't need to take you to it. It's a normal strikeout power. It's
I think
MS.
you refer to it in your printed case.
That's right. It's MS 1175. And also there's a specific power to give summary judgment if the applicant has no real prospect of success. Again, just for your notes, Rule 43 sub 1 sub A sub Roman 1, that's at MS 1176. These powers, strikeout, summary judgment, are distinct from the certification provisions. And when I go through the tribunal judgment, what I'll show you is that the tribunal was here concerned with certification and the certification provisions and was not concerned with the substantive merits of the claim. Now, to come to what my response to Lord Kerr's question is, the nub of this part of the appeal is the approach to expert evidence, which the tribunal adopted, and the related question of, well, was that an approach that was open to the tribunal to adopt as a matter of law? And if you go to MS 259, this is where the tribunal sets out the basic approach that it adopts to expert evidence in certification hearings. And you'll see the reference to process, and the quote from Justice Rothstein's judgment in paragraph 118 of Microsoft and Process. And I wish to make the following points in relation to the test. First of all, according to the tribunal, the expert methodology must be sufficiently credible or plausible. Secondly, the methodology cannot be purely theoretical or hypothetical. It must be grounded in the facts of the particular case in question. Thirdly, there must be some evidence of the availability of the data to which the methodology is to be applied. So let's pause a moment. Let's try and digest what that actually means. First of all, an applicant must put forward a sufficiently credible methodology as a matter of theory. The proposal must be logical, it must be coherent. However, it is not enough that the proposed methodology is coherent as a matter of theory. It must also be workable and practical given the facts of the particular case in question. An aspect of the need for the methodology to be grounded in facts is that there must be sufficient evidence to satisfy the tribunal that the data necessary to apply the methodology in practice will in fact be available. A methodology that is conceptually plausible but practically unusable will not render claims suitable for an aggregate award of damages within the meaning of the tribunal rules. And that leads us to the question, what does some evidence of the availability of the data mean in the context of the UK legislation? And in our submission, it means sufficient evidence to satisfy the tribunal that the claims are suitable for an aggregate award of damages, because that's what Rule 79(2)(f) says. That is the test set down by Rule 79 sub 2. And the question of whether that threshold has been met will be a matter of judgment for the tribunal on the facts of each particular case. Now I'll come back to Canadian law towards the end of my submissions on issue 1, because our submission, as you know, is this is not an issue of Canadian law. This is a question of interpretation of the United Kingdom legislation. And in relation to this issue, approach to expert evidence, that is the position that Mastercard said was adopted by the tribunal and was lawful under the domestic legislation. The next section of the judgment, it's paragraph 60 at the bottom of MS 259, deals with a different issue, not of suitability, but of common issues. You remember I showed you this morning, they are in fact two separate criteria. And at paragraph 60 to 67 of its judgment, the tribunal considered the extent to which the claims raised the same, similar or related issues of fact under section 47B sub 6 of the Competition Act. And as I said, that's a distinct question from whether the claims were suitable to be brought in collective proceedings. If you could go to MS 261, paragraph 63.
Sorry, Mr. Hopkins.
Oh, I'm sorry, Mr.
The quotation from the Canadian case that is put front and centre is in fact discussing the common issues requirement, is it not?
Yes, I'm going to, that's one of the...
It's discussing what you say is a totally distinct requirement from the one that matters in this case. Does that affect things at all?
You're absolutely right, and it's one of the points I was going to make to you when we come to the Canadian law, because the Canadian requirements for certification are not exactly the same as the United Kingdom requirements. The submission I make is that what the tribunal is doing is it is taking the words of Mr. Justice Rothstein and it's saying that's a pithy summary, that's the summary of the approach we want to adopt as a matter of United Kingdom law. So if, for example, there has been no reference to Microsoft at all and the tribunal had simply set that out in its own words, that would have been the approach it wanted to adopt under United Kingdom law, and we'd be having a debate, nothing to do with Canadian law, simply was that acceptable under United Kingdom law. Now, the fact it is not actually in Microsoft, it was actually dealing, as you say, with commonality rather than suitability for aggregate damages, doesn't mean that the approach adopted by the tribunal isn't acceptable under English law. As I'll come on to, what it means is you have to treat the Canadian authorities with a degree of care. But as an exposition of how the tribunal will treat expert evidence under the United Kingdom legislation, just read that passage as if there was no reference to Microsoft, and let's approach it on that basis.
Well, just going back to my earlier question,
Oh dear.
there are three elements, you say, in the Canadian case. First of all, it must be a methodology which is sufficiently credible or plausible, presumably at a theoretical level. But then the methodology must not be purely theoretical or hypothetical. And finally, there must be some evidence of the availability of the data to which the methodology is to be applied. Well, now, is there a pithy, to use your expression, summary of those that we can distill into a test other than an arguable case and something falling short of a mini trial?
I would put it, and I'm sorry, I'm repeating myself, and therefore I probably haven't done a good enough job the first time. But let me repeat the answer, and then you can see if I can coax something better out of me. But what I start with in terms of this is it's a question of statutory interpretation of the UK provisions, the Competition Act and the Tribunal rules.
Yes, go on.
You know where I'm headed. What the Tribunal rules tell us is that the applicant must satisfy the tribunal that the matter is suitable for an award of aggregate damages. That assessment must be carried out on the facts of each particular case. And that assessment is a matter that the legislation has left to the judgment of the tribunal. The legislation, we also know, has said that the only basis upon which that exercise of judgment by the tribunal may be interfered with is if there is an error of law. So if, for example...
Well, I'm sorry to interrupt, but...
no, please do.
The suitable for an award of aggregate damages, how does one address the question of the suitability of the particular case for an award of aggregate damages? If it is something beyond merely raising an arguable case, then I would be interested, indeed assisted, to know how one approaches that question.
Well, certainly my submission is that the tribunal did not adopt a greater than arguable case test. What the tribunal did, again, I'll come on in more detail, but let's try and map the way we're going. It was actually the Court of Appeal that introduced the notion of reasonable prospects of success, as we'll see when we come to the Court of Appeal's judgment. But when the tribunal dealt with this at paragraphs 58 to 59, and in the quote from Microsoft, there is no reference by the tribunal to a reasonable prospect of success test. What the tribunal did was it set out this approach to expert evidence. Then, as we'll see, it went to analyze what the applicant's experts had put forward as A, their methodology, and B, the evidence that would be necessary to support their methodology. And the tribunal looked at that.
Again, I'm very sorry to interrupt you.
Please do.
Does that mean that, in effect, you say the tribunal did approach the matter on the basis that all that the applicant had to do was to show an arguable case?
The reason I'm not plunging headlong into arguable case is because arguable case tends to connote an argument on the merits. And it puts you into the realm of strikeout and summary judgment. And as I've submitted, it's quite clear that the legislation actually distinguishes between certification criteria and merits of the case in terms of strikeout or summary judgment. And the legislation and the rules could have, for example, used the language of reasonably arguable case in relation to certification, but they don't. And there must be a reason for that. They only use the language of reasonably arguable case insofar as they talk about strikeout or summary judgment. So when one is looking at the criteria for certification, one is not looking at the substantive merits of the case. Now, it may well, I don't know if that's answered your question. That's why I'm not simply saying yes, it's a reasonably arguable case for certification, because the legislation has made it.
I had understood you to say earlier that you weren't, that you didn't consider that the tribunal had departed from the notion that an arguable case would be sufficient. But I may have misunderstood what you were.
Sorry, my point is going to be that the tribunal didn't adopt that specifically as its approach. You don't find that language in the tribunal judgment. Now, to make it clear, I'm not saying that the tribunal adopted a higher approach. I'm simply saying that's not the way the tribunal argued or reasoned. It set out paragraphs 58 and 59, and it then purported to apply that test on the basis of the facts and evidence before it and reached a judgment.
Well, let's move on.
I was going to move on to paragraph 60 at the bottom of 259, and I made the point that this section of the tribunal judgment deals with the commonality issue and not the suitability issue. And we were going to look at paragraph 63 on page 261. And this is one I've shown you before. Look at it again in the context of the reasoning on this issue. As regards pass-through, the experts in their oral evidence accepted there is likely to be significant variation, not only as between different kinds of goods and services, but also different kinds of retail outlet. Paragraph 66 on page 262. Pass-through cannot be described as a common issue in any meaningful sense, and the level of individual spend is manifestly not a common issue. And the reason why the tribunal found that pass-on was not a common issue was just because every consumer has a different spending profile. Some of you might like to spend your money on fine wine. Some of you might like to spend it on Arsenal season tickets. Some of you may be parsimonious Scots. But the point that the tribunal was making was if you're looking at the nature of the individual claims, they're not sufficiently similar to be common issues. But that's not the basis upon which the tribunal dismissed the application. It wasn't on the basis of a lack of commonality, and you see that in paragraph 67 of the judgment. However, that in itself does not mean that this case is unsuitable for a CPO. There is no requirement that all the significant issues in the claims should be common issues, or indeed that the common issues should predominate over the individual issues. What is required, in the words of section 47 sub 6 of the Competition Act, is that the claims are nonetheless suitable to be brought in collective proceedings. Here the applicant seeks to address the problem of pass-through by submitting that the tribunal can arrive at an aggregate award of damages, which would then be distributed to the class members. We accept that in theory this may be a permissible approach. So there you have, in terms of the test, as a matter of theory, is this plausible? The tribunal says yes. But before adopting this approach, it is necessary to consider whether in practice the applicant has put forward a sustainable methodology which can be applied in practice to calculate a sum which reflects an aggregate of individual claims for damages. 2, which relates to the second issue we'll come on to, a reasonable and practicable means for estimating the individual loss which can be used as a basis for distribution. So the point I want to make in relation to this is the tribunal found that pass-on was not a common issue, but that is not the reason it refused the application. It refused the application because it goes on to find that the proposal for aggregate damages was not a suitable one in practice. So let's move on to the Commission's analysis of suitability. Paragraph 68, the bottom of 262, you'll see the heading aggregate damages. And first of all, the tribunal summarizes the approach which the applicant's experts were putting forward. And you'll see it's the weighted average approach that we saw in their report. And you'll see at the top of page 263, the weighted average would reflect the different levels of pass-through in different sectors or market, and the proportion which card expenditure in those respective sectors or markets bore to the total. That's why you need to know the level of pass-through for each of the sectors, because without that information, you cannot come up with a weighted average.
But how are you to discover that without discovering it?
Well, what one has to do, again, and I'll come on to this in more detail, is it's certainly not the case that one has to produce all the evidence that is available and say we've collected it all, here it is. But what one does have to do at the other end of the spectrum is to, again, using the statutory words, satisfy the tribunal that it's likely that the evidence will be available. And as we'll come on to see, whilst the experts identified some empirical evidence in relation to the petrol and supermarket sectors, there was actually evidence that there was not empirical evidence for other sectors. So that's the way I'd put it. I keep, in a sense, and I understand probably a degree of frustration, I'm sort of ducking putting hard-edged legal tests onto these various issues. But the reason I do that is because that's the way the legislation is drafted. It sets out certain criteria. It gives the tribunal a broad discretion. It gives the tribunal the power to make the judgment. And then it says, but appeal is limited to point of law. That's why I avoid the hard edges, because that's what the legislation has set up the system as the means by which it should operate. Can I move in? I think, Lord Kerr, this will hopefully start to give you a more satisfactory response to the question you've just put to me. Because what the tribunal then does is, having set out what the applicant's own methodology is to look at what the data is that the applicant says would be available to allow the methodology to be applied. Paragraph 69. The experts expressed the view that it should be possible to carry out the necessary analysis to arrive at an estimated weighted average on the basis of information from the many claims brought against Mastercard by retailers from a wide variety of sectors, disclosure from third parties, and publicly available data. We comment on these methods in turn. Now, first of all, the heading Other Actions Against Mastercard. This is dealt with at paragraphs 70 to 73. Now, it's certainly the case that a large number of retailers have brought actions against Mastercard, and indeed Visa as well. However, as you'll see from the tribunal's judgment, those actions largely covered different time periods to the time period covered by the claims that the applicant sought to bring on a collective basis. With very few exceptions, the applicant's claim covers a much earlier time period than the retailer actions do. There is very little overlap. So the idea that there is an off-the-peg source of pass-on information for retailers is wrong, because the time periods do not correspond. And that's what the tribunal found, having looked at the time periods of the retailer claims, because we brought forward the details of the dates of the retailer claims. The tribunal also made the point, the one that we've covered a couple of times this morning, that in the only case to go to trial, retailer against Mastercard or Visa in relation to the issue on pass-on, the Sainsbury's and Mastercard case, the tribunal found no evidence that pass-on at any level had taken place to consumers. The third point made by the tribunal is that most of the retailer claims were at a very initial stage. There was no realistic expectation that they might progress to the point of producing evidence on pass-through until the appeals against the first instance judgments in the Sainsbury's case and also the Morrison's case in front of Mr. Justice Popplewell were resolved. And indeed, that statement by the tribunal has been proved correct because, as my Lord Kerr indicated at the start, the appeal on those trials has only just reached the Supreme Court, and we're awaiting judgment on that. And all the other retailer actions are basically held up behind that. But the main point is the timing one. It's simply not the case that there is a package of evidence relating to pass on by retailers to consumers waiting in these actions. Now, those conclusions by the tribunal in relation to the other actions against Mastercard are clearly not open to challenge as a point of law. No error of law in paragraphs 70 to 73. And an important point to make is that contrary to the suggestion in the applicant's written case for this court, Mastercard itself will have little, if any, relevant disclosure to give in relation to the extent to which merchants pass through any part of the MIF to their customers by means of higher retail prices. Mastercard simply doesn't have visibility of that. Mastercard has no role to play in the prices, the retail prices that retailers set. The basis upon which merchants set their prices is a matter known to them, not Mastercard. So again, there is no package of disclosure sitting in Mastercard's hands that can be given on retailer pass on. It doesn't exist in the retailer actions. Mastercard doesn't have it. Now, the second heading is disclosure from third parties. That's MS 264, paragraph 74. Now, of course, the disclosure in the retailer actions, even if it were relevant, Mastercard couldn't simply pass it over because it's subject to restrictions as to the use it can make of disclosure gained in one action for other purposes. So disclosure would have to be sought from third parties if the applicant wants to rely on that information. And at paragraph 74, what the tribunal states in relation to third-party disclosure is it would obviously have to be extensive because we're dealing with the whole of the United Kingdom economy, 11 sectors comprising between 500,000 and 800,000 retailers. And the tribunal finds that third-party disclosure on that basis, because of the scope of the action, would be wholly impractical. And it gives a number of reasons. First of all, in view of the number of sectors or markets to be considered, the long period involved, 16 years of the claim, and the wide range of data required to arrive at a meaningful estimate, this would be a very burdensome and hugely expensive exercise. And that chimes with some of the responses I gave to Lord Sales's questions this morning. We're not dealing simply with one retailer against Mastercard. We're looking at pass on for all the UK economy to all their consumers. The second point which the tribunal makes is that applications by retailers, applications against retailers for relevant disclosure would likely to be hotly resisted by the retailers because the basis upon which they set their prices is incredibly commercial sensitive. They're not simply going to roll over and say, here you are, here's our commercially sensitive price setting information. And the third point made by the tribunal is that the applicant would have to pay the various third parties' costs of compliance, because that's the normal order where third party disclosure is ordered, that the person seeking the order has to pay the third party's costs of complying with the order, not just the costs of the application, but of actually carrying out the disclosure exercise. And the tribunal noted that the cost budget filed with the CPO application did not provide for the sorts of costs that would be entailed if one were envisaging third-party disclosure on this scale. And again, the conclusions of the tribunal on third-party disclosure are not open to challenge as a point of law. You might say, well, I'm not sure about this one or that one, but they're not errors of law in that analysis. And then the third category is published data. So this is, well, is there the equivalent out there of the information that the experts identified for petrol and supermarkets? Does it exist? Has the work been done? Now here we need to go to the RBB report, which, as you've seen, the applicants' experts introduced themselves as evidence in the case. If you could go please to MS 2417.
Yes.
So you'll see, sorry, bear with me while I catch up. A report of RBB Economics, prepared in February 2014, and it was prepared for the Office of Fair Trading. And you'll see the title of it, Cost Pass-Through Theory, Measurement and Potential Policy Implications. If you could go to MS 2418, you'll see a foreword. Then cost pass-through describes what happens when a business changes the prices of the products or services it sells, following a change in the cost of producing an item. And then skipping on to the second paragraph, this report on cost pass-through has been commissioned by the Office of Fair Trading, OFT, from RBB Economics. It provides a comprehensive and up-to-date review of the literature on the causes and consequences of differences in cost pass-through and their measurement. So this is a comprehensive and up-to-date review of the literature on the measurement of pass-on. MS 2421, the executive summary. Again, you'll see the introductory words just explaining what RBB has been commissioned to do. There's then the summary of the insights from the theoretical literature. We are interested in the empirical evidence, which is on 2423. Empirical work on cost pass-through issues in industrial organizations settings is relatively new, and analysis that attempts to quantify pass-through rates in this context is scarce. Most notably, we have identified few studies that shed light on the relationship between cost, pass-through, and market structure and competition. Moreover, the pass-through measures reported in the empirical literature, notably pass-through elasticities, are often difficult to interpret and compare. And then, nevertheless, there is a small body of empirical work that has considered pass-through at the firm level, both in response to industry-wide and firm-specific cost changes. The evidence suggests there may be significant differences between firms in the extent of cost pass-through, even in response to industry-wide cost changes. So again, going back to a response I gave to Lord Sales this morning, one simply cannot assume in a given market that because a company wants to pass on a cost in full, it will be able to do so. In other words, firm-level asymmetries appear significant. There is some empirical support for the theoretical proposition that industry-wide pass-through rates will typically be greater than firm-specific pass-through rates, though no clear evidence emerges on the extent of the difference between pass-through rates and how this might change the intensity of competition varies. And then there's a detailed report, which I don't have to trouble you with at the moment. Now, the applicant criticizes the tribunal's reliance on this report that the applicant's own experts brought before the tribunal. But let us just remember a couple of points. Under Rule 79 sub 1 of the tribunal rules, it was for the applicant to satisfy the tribunal that the claims were suitable to be brought in collective proceedings. The applicant has to bring the evidence forward. If we could go to MS 264, paragraph 75, this is where the tribunal addresses the availability of published data, because we either are dealing with the retailer actions, some other form of third-party disclosure, or published data. And at 75, the tribunal finds the experts emphasize that there's a lot of published data and studies on the passing on of input costs and on credit and debit card usage. And I've taken you through the relevant paragraphs of the experts' reports. However, that is precisely the material surveyed in the RBB report, which found it incomplete and difficult to interpret. We have no doubt that some sectors have been the subject of detailed study, and we've seen that for petrol and supermarkets. But there is nothing before us to contradict the overall finding of the RBB report. We note that no real attempt appears to have been made to consider what data are available for each of the broad sectors over the relevant period. The only empirical studies that relate to the level of pass-on in specific parts of the economy, petrol and supermarkets. You have my submission on that. It's not even the whole of the sectors they occupy. And again, let's remind ourselves what data the applicant experts themselves said would be necessary to carry out their proposed methodology. You've already seen it, but it bears, I think, looking at briefly again. MS 543, Experts Report, paragraph 6.2.4. If MSC pass-on rates are found to be significantly different for different sectors of the United Kingdom economy, then we may be able to calculate a weighted average pass-on rate weighted by reference to the VOC and pass-on rate associated with each sector during each year of the infringement period. Now, the applicant's experts simply haven't shown that the empirical evidence is even potentially available for anything other than petrol and supermarkets. What they were asking the tribunal to do was to say, well, look, here's petrol, here's supermarkets. We just want you to assume that we can get similar stuff for the rest. The tribunal said, I'm sorry, that's not good enough.
What if, upon discovery from your client, it was revealed that there was ample evidence on which a collective action could be based? Is it possible to renew the application?
Subject to limitation, yes, they could make a new application. Sorry, if there's been disclosure, by definition, certification has been granted. Sorry, but I'm not following the question, my lord.
Yeah, well, no, let's suppose an individual had taken proceedings against Mastercard and obtained discovery which revealed wholesale pass-on practice. Could an application then be made for a collective action?
If brought within the limitation period, yes. But I make the point again. I'm sorry to repeat myself. Mastercard doesn't hold this information. It's not privy to retailers' pricing practices. Mastercard operates the credit card business, but it's nothing whatsoever to do with the prices charged to consumers. So I think I understand the point. I understand why you make it to me. But the suggestion that Mastercard would even have that evidence.
Well, we don't know whether it has that evidence or not, because there hasn't been discovery.
But I make the point. It's inherently unlikely for the reason I've given. If Mastercard were to hold that information, it would be as a result of itself getting disclosure in retailer actions. That disclosure would be subject to restrictions on the use it could be put to. And as I've already made the point, the retailer actions that exist do not largely cover the same time period, so they don't help.
Yeah. Now, Lord Thomas has a question.
Could I take you back to the CAT judgment at MS 258, paragraph 57, and the top of page 258, where the CAT say that the applicant has to do more than simply show that he has an arguable case on the pleadings. Really, we're not into pleadings here. We're into the level of evidence. What is the test you think ought to be applied to the level of evidence that is required? Because that is the nub, I think, of your
I agree.
submission.
I absolutely agree. My evidence is that the test to be applied is set out in the rules, in the legislation and the rules. It is that the tribunal must be set. Shall we go to Rule 79.2? Maybe that will help. Let me just find the reference. So MS 1182.
Yes.
79, Rule 79 sub 1, the tribunal may certify claims as eligible where, having regard to all the circumstances, it is satisfied by the proposed class representative that the claims sought to be included in the collective proceedings, ABC, including, are suitable to be brought in collective proceedings. In determining whether the claims are suitable, the tribunal shall take into account all matters it thinks fit, including, and then F.
But what is the level of evidence that you have to have at this very preliminary stage, bearing in mind that there is an alternative of summary judgment and strike out at a later stage? What is it that you have to prove at this stage? A ... case. What's the ...
Well, the three criteria that must be established, particularly in relation to expert evidence, is a plausible expert methodology that can be carried out in practice, and there is some evidence of the availability of the data to which the methodology is to be applied. What it doesn't...
Some evidence of the availability of the data.
Yes.
Because that, I think, is... There's no quarrel about the methodology. It's the level of evidence on the data that you seem to be focused on.
Yes, because in my submission, I'll make the point in two ways. If one takes the legislation that we've just seen, and then one looks at what the tribunal did, and one looks at what evidence this applicant produced, my submission is that the tribunal was entitled within its powers under the Act and the rules, given the paucity of the evidence put forward, to reach the judgment that it did.
Thank you very much.
I'll put it in the alternative. This is not my case, but if...
I think Lord Briggs has a question.
Sorry, can I just finish responding?
By all means,
Please do.
Lord
Sorry.
Briggs.
If this court were to find that the test, although it doesn't appear on the face of the legislation, were the reasonable cause of action, I would say that in this case, the applicant clearly still didn't meet it, because the applicant's own experts said what data would be necessary to carry out their methodology. And yet the applicant's experts failed to, even in the tribunal's words, really to look into whether the data was available for their own methodology. So I put it the primary way on the basis of the language of the legislation, but I have that alternative that even if the test is reasonable cause of action, it clearly still wasn't met in this case. Sorry,
Lord Briggs.
Lord Briggs.
Mr. Hosking, if some evidence is actually the correct test, which I think is the one you're propounding, if one's looking at sort of available evidence predictions at the certification stage, or some evidence of the availability of data by the time of trial. If you look at paragraph 75 of the CAT judgment on page 258, they seem to think that the fact that in the RBB report, the material which they surveyed was incomplete and difficult to interpret meant that it didn't pass that test. But isn't it the regular experience of participants in legal proceedings where some quantification or valuation or estimation process has to take place, that it's very often done from material which is incomplete and difficult to interpret? And those difficulties are ones which the court is there to deal with.
But I think the problem here is that what the tribunal is doing in paragraph 75 is encapsulating in very short order what one finds in the totality of the RBB report. Now, I showed you the executive summary of the RBB report, but what the applicant's experts said they needed was evidence of level of pass-through for each of the sectors. And what the RBB report tells us is that that evidence isn't out there. And the applicant's experts, as the tribunal notes at paragraph 75, didn't actually make any attempt to consider what data was available for each of the broad sectors. So that's why I took you in detail to the applicant experts reports, because what you see, and they really are snippets of references to there's this and there's that, but they are snippets. But what hasn't been done is any attempt to meet the standard which is set down by the legislation and to say, this is our methodology. The experts accept that evidence is necessary to operate their methodology, but then to put forward a coherent explanation of why they think that data will be available. That's what you don't find. Now, I appreciate this is slightly odd because I started out by saying this is an appeal on a point of law. And here I am diving into the detail of the evidence. But that's because my submission is the approach adopted by the tribunal was entirely consistent with and permitted by the legislation. And what this really is, what's really happened in this case is the Court of Appeal, under the guise of an error of law, has interfered with the tribunal's judgment on the detailed evidence before it. That's what's gone wrong here in the Court of Appeal. Sorry, Lord Leggett has a question.
Yeah, sorry, Lord Leggett.
I come back to the point, if you don't mind, Mr. Hopkins, that the tribunal seems to think that the claims are not suitable for an aggregate award of damages unless there is evidence for each of the sectors. They acknowledge that some sectors have been the subject of a detailed study. So why can't the claims proceed on the basis that they may not succeed on all sectors and some sectors but not others, but that's to be worked out in the course of the proceedings? Why does it have to be all or nothing at the outset?
It doesn't have to be all or nothing, my lord. 2 points. One, the tribunal didn't find, I don't think there was evidence for 2 sectors, because as I said, supermarkets and petrol are only subsets of 2 sectors.
Well, I was just reading the sentence. We have no doubt that some sectors have been the subject of detailed study. So
indeed,
they're,
I think
they're
that
envisaging that there's a prospect of getting data for some sectors.
Well, I think the only evidence we have is petrol and supermarkets, but that's not your main point. That's not the point you want to test me on. The point is this: if an applicant comes to the tribunal with a claim of this scope, and if during the hearing it becomes apparent that the applicant has not brought forward sufficient or indeed any evidence to cover the whole scope of the claim, then certainly the applicant could say to the tribunal, we will just limit the claim to the following. But the problem for the tribunal is it's not in the tribunal's power to cut down the scope of the claim. The applicant brings a claim before it. You've seen the scope of the claim that's brought, and the tribunal has to decide whether it's going to certify that claim or not. The question of all or nothing in my submission is really a question for the applicant, not for the tribunal. Well, that's particularly important in this context where, of course, the claims are dependent upon funding. Because if the tribunal starts simply saying, okay, we see the claim you've brought, but we'll give you permission for this, but not that, that obviously potentially has major implications on the basis of the funding for the claim. And the tribunal has to certify not just on the issues we're looking at, but whether the funding is in place. So the onus really, if there is a good claim hiding in here, is for the applicant to bring it out and bring it and ask for it to be brought in that way. It's not for the tribunal to winnow through the aspects of the claim and to alight upon what it thinks the applicant should be doing.
Right, let's move on.
Certainly. The conclusion on the issue in the tribunal's judgment is at paragraphs 77 to 78. accept that in theory the methodology is methodologically sound, but making every allowance for the need to estimate, extrapolate and adopt reasonable assumptions to apply that method across virtually the entire UK retail sector over a period of 16 years is a hugely complex exercise requiring access to a wide range of data. We certainly would not expect that analysis to be carried out for the purposes of a CPO application, but a proper effort would have had to be made to determine whether it is practicable by ascertaining what data is reasonably available. There's the truth of the matter. The reason why this application failed is that a good enough job hadn't been done on the evidence. That's why it failed. And I made the point about funding, about the commercial aspect of the claim. If you want to bring a claim on behalf of the whole population of the United Kingdom, you have to do a proper job. And the evidence just wasn't done properly in this case. That's why it failed, not a point of law. 78, applying the Microsoft test, we are unpersuaded on the material before us. It's an assessment of the evidence. We are unpersuaded on the material before us that there is sufficient data available for this methodology to be applied on a sufficiently sound basis. Although we are not satisfied, and indeed very much doubt, that the claims are suitable for an aggregate award of damages, see Rule 79 sub 2 sub F. So that's the tribunal's approach. Let's go to the Court of Appeal judgment, MS 219. So I'm jumping in at paragraph 40 of the Court of Appeal judgment. You see in the middle of paragraph 40, about 10 lines down, our view is that the CAT was right to treat the Canadian jurisprudence on certification as informing the correct approach. And then at paragraphs 41 to 44, the Court of Appeal then considered the Canadian case law, including Process and Microsoft. Then paragraph 44, I need you to, because suddenly it switches from dealing with the Canadian case law to a conclusion on what looks like English law. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 lines down. You'll see the words to sales of Microsoft software in Canada. I'd like to pick it up after those words. It seems to us that at the certification stage, the proposed representative must be able to demonstrate that the claim has a real prospect of success. Now, that's not actually what the CAT said, as I've shown you. The words real prospect of success don't appear in the CAT's judgment. But then the Court of Appeal goes on to say, to do so in this case, he had to satisfy the CAT that the expert methodology was capable of assessing the level of pass-on to the represented class, and that there was or was likely to be data available to operate that methodology. So the tribunal and the Court of Appeal were ad idem that it was permissible in a certification hearing for the tribunal to ask itself under the domestic legislation whether the expert methodology was capable of assessing the level of pass-on and whether there was or was likely to be data available to operate that methodology. The Court of Appeal didn't cavil with that part of the tribunal's judgment. So what then was the supposed error of law that the Court of Appeal identified? If we can go to paragraph, page 224, paragraph 54, the assessment of these matters is, of course, a question for the CAT to decide using its substantial expertise. And in this appeal, we can only interfere with the decision to refuse a CPO if there has been a demonstrable error of law. But in our view, the approach taken to the expert evidence in this case was based on a misdirection as to the correct test to be applied in relation to whether the proposed representative had demonstrated that the claims were suitable for inclusion in collective proceedings, and in particular for an aggregate award of damages. So a misdirection of law is apparently what the tribunal was guilty of. At paragraphs 45 to 47 of the Court of Appeal's judgment, beginning on MS 222, the Court of Appeal addresses the commonality issue and finds that the tribunal was wrong to find that pass on to consumers was not a common issue. So the Court of Appeal disagrees on that, but as I've shown you, that was not the basis upon which the tribunal refused the application. It was suitability, not commonality. So I am going to, for obvious reasons, move on to suitability. Now, the complaints that the Court of Appeal makes about the tribunal's judgment are found sort of in different parts of the judgment. And what I've endeavoured to do is to try to bring them together under 3 headings. And I'm not saying these, I'm sorry, Lord Sales.
Yeah, sorry, Lord Sales.
Yes, I mean, just on the interaction between commonality and suitability, isn't the degree of commonality capable of being a factor relevant to suitability? So if the CAT had gone wrong in minimizing the degree of commonality, which the Court of Appeal thought it had, would that not be a basis for saying that they've exercised their evaluative judgment in relation to suitability on an improper basis, thereby opening it to appeal, to allow the appeal and either exercise the discretion itself or remit?
If that is what the tribunal had in fact done, but my submission is that's not what it did, and I took you to those parts of its judgment. The applicant has not suggested anywhere that that's what's happened and somehow there's a balancing exercise has gone wrong. The Court of Appeal doesn't suggest that.
All right, thank you.
My submission is if you go to, I won't go back to it now in the interest of time, but it's quite clear in my submission, the tribunal judgment says we've made this finding on commonality, but because commonality, you don't have to have commonality in all issues, and because the issues in which you do have commonality don't be preponderant, that's not the reason we're going to refuse this application. If that had indeed been the basis, that there had been a balancing of commonality and suitability, you'd see it in the judgment, but you don't see that balancing taking place on the face of the judgment. So my categorization, 3 categories, what I've called them effectively substantive complaints, procedural complaints, and a complaint about the continuing nature of a collective action. Let me deal with what I've called loosely substantive complaints. The Court of Appeal found that the tribunal applied too high a threshold to the applicant in 2 related ways. First of all, the Court of Appeal held that the tribunal required the applicant to establish more than a reasonably arguable case, which would have been the test had Mastercard applied to strike the claim out. And you see that, for example, at paragraph 52 of the Court of Appeal judgment at MS 223. The second sentence of paragraph 52, they also required the proposed representative to establish more than a reasonably arguable case. You see it at paragraph 44, MS 222. The Court of Appeal said the purpose of a certification hearing is to enable the CAT to be satisfied that with the necessary evidence the claims are suitable to proceed on a collective basis, not that the claims are certain to succeed. You'll see that 3 lines up from the bottom of paragraph 44. Not that the claims are certain to succeed. Paragraph 48 at page 223. In our view, the CAT demanded too much of the proposed representative at the certification stage. Paragraph 54, 224. At the certification stage, the proposed representative should not, in our view, be required to demonstrate more than that he has a real prospect of success. That is not the test which the CAT applied. And then the second way in which the Court of Appeal complained about the threshold it said the tribunal applied was it said that the tribunal required the applicant's experts to specify in detail what data would be available at trial for each of the relevant retail sectors in respect of the infringement period. And you see that at paragraph 51, MS 223. It's in the second sentence. Although the CAT was entitled to satisfy itself the methodology was credible, it was not appropriate at the certification stage to require the proposed representative and his experts to specify in detail what data would be available for each of the relevant retail sectors. And also at paragraph 44, back to MS 222. Appeal said it was not necessary at that stage for the proposed representative to be able to produce all of that evidence still less to enter into a detailed debate about its probative value. Now, in our submission, there was no such error of law by the tribunal. First of all, pursuant to section 47b(6) of the Act and rule 79(1) of the rules, the tribunal could only make a CPO where it was satisfied by the class representative that the individual claims which the applicant sought to combine were suitable to be brought in collective proceedings. The onus was on the applicant to produce sufficient evidence to the tribunal to satisfy it that this condition was fulfilled. The language of reasonable cause of action or anything of that ilk does not appear on the face of the legislation. Pursuant to Rule 79(1) of the Tribunal Rules, one of the matters that the Tribunal had to take into account was whether the individual claims were suitable for an aggregate award of damages. In considering whether it was satisfied that the claims in this case were suitable for an aggregate award of damages, the Tribunal held that the methodology proposed by the applicant had to be grounded in the facts of the particular case in question, and there must be some evidence of the availability of the data to which the methodology was to be applied. In our submission, that approach is entirely consistent with the wording of the relevant legislation, and the Court of Appeal agreed that those were relevant considerations to certification under the legislation. I showed you paragraph 44 of the Court of Appeal judgment. In the applicant's experts' joint report, they proposed a methodology which depended on being able to calculate a weighted average pass-on rate. I've shown you those experts explained in their own words that in order to apply that methodology, they would have to have sufficient evidence to calculate the pass-on rate associated with each sector of the UK economy throughout the period. Sorry, Lord Briggs has raised his hand.
Yeah, sorry, Lord.
They surely didn't say, I don't think, calculate as if you can get to a precise figure on the basis of evidence. Each sectoral item that goes into the weighted average would probably itself be a matter of judgment and extrapolation, possibly in a sector for which there was no direct evidence by reference to the most comparable other sectors.
Again, I'm not seeking to hang anyone by the words they used. There will be a great...
I don't think they even used the word calculate.
Well, that's my fault then. I wasn't intending to... I'm intending simply to summarise the language I've shown you in their report, my lord. So I'm sorry if I've not done it accurately. There's nothing loaded intended by my use of the word calculate, and it's not. And to make absolutely clear, it's not the test I say they would have to meet, nor is it the test the tribunal required them to meet. So I'm sorry for that slip on my part. The experts also explained that their approach depended on the availability of evidence. They accepted that themselves. Now, the experts suggested that the evidence necessary to apply their methodology could be obtained from three sources. They said it could come from the claims brought by retailers against Mastercard. But the tribunal noted that, as a matter of fact, those claims actually cover largely different time periods from the claims that the applicant sought to bring. So there isn't that ready-made package. The third-party disclosure point, the tribunal found it being impracticable because of its scope and cost. The publicly available data point, the RBB report referred to by the applicant's own experts, contained a comprehensive and up-to-date review of the available literature on the measurement of cost pass-on, and it found that the attempts to quantify pass-through rates were scarce. And the applicant did not produce any evidence before the tribunal to contradict the overall findings of the RBB report. All the applicant did was to point to a report relating to petrol, a report relating to supermarkets. And the tribunal also noted, our submission absolutely fairly, that no real attempt appeared to have been made by the applicant or his experts to consider what data might be available for each of the 11 sectors of the UK over the relevant period, even though that was data which the experts had explained would be necessary to implement their methodology. So you'll see therefore my submission is a simple one. The tribunal's approach of asking whether the methodology proposed by the applicant was sufficiently credible and that there was sufficient evidence of the availability of the data to which the methodology was to be applied was entirely consistent with the obligation upon it to consider whether the individual claims in this case were suitable for an aggregate award of damages. And there's no real dispute about that. The manner in which the Competition Appeal Tribunal, the specialist tribunal, applied the approach to expert evidence in the particular circumstances of this case in our submission was clearly reasonable. The applicant's experts themselves identified the evidence that would be necessary for their methodology, but they didn't even consider whether that evidence would in fact be likely to be available. They didn't turn their mind to it in their report. And the Court of Appeal was not permitted to interfere with the specialist tribunal's assessment of the evidence, of the availability of retailer disclosure, third-party disclosure, and the sort of disclosure or data rather covered in the RBB report. The tribunal did not require the applicant to satisfy it that its claims were certain to succeed, as the Court of Appeal suggested. You will search high and low, and you will not find that language in the tribunal's judgment. Nor did the tribunal require the applicant to produce all of the evidence necessary to operate its methodology. The tribunal's finding was based on the failure of the applicant to even address his mind to the availability of the evidence that he said would be necessary. It wasn't saying you must produce all the evidence that is necessary. Again, you just don't see that in the tribunal's judgment. Now, contrary to what appears to be stated in Which's written intervention, again, there's no requirement on an applicant to obtain the relevant data before certification. But what an applicant does have to do is to identify potential sources of information. And in a normal case, take Lord Legate's point, if this was a case that was limited to petrol, and that had been brought and the evidence had said, there is the evidence on petrol, then certification obviously would have been much more likely in that case. But the problem here is the scope of the application that the applicant has sought to bring. And by choosing to bring an application of that scope, the applicant was inevitably bringing upon himself the obligation to demonstrate to the tribunal it was going to be practicable. And the onus was on the applicant to do that. As I've said, the simple fact, as you've seen, is that the applicant failed to produce the necessary evidence in this case. There's no error of law, simply it's a failure to produce the necessary evidence. Can I deal with the way the applicant seeks to meet this point? Can we look at the applicant's written case at paragraph 29? That's MS 159. I'll pick it up in the final four lines, the final sentence. The tribunal applied a more stringent threshold that was directed to the substantive merits of the claims, the likelihood of succeeding at trial, rather than to the relevant statutory requirement of the eligibility for collective proceedings. Now, this is why I was so resistant earlier in terms of mixing the merits of the case with the certification requirements, because that is what the applicant is accusing the tribunal of having done, but that allegation is not correct. And the reason why it's not correct is, again, and I'm certainly trying not to repeat myself, but as you've seen, that the tribunal can only make a CPO if it has been satisfied by the class representative that the certification requirements are met. And the certification requirements do not include the merits of the case. They might do in another case, but they didn't in this case. One of the matters that the tribunal has to take into account in deciding whether claims are suitable is whether they're suitable for aggregate damages award. The tribunal and the Court of Appeal agree that in considering whether claims are suitable for an aggregate damages award, the tribunal consider whether the methodology proposed is a plausible one and whether there is some evidence of the availability of the data. Ad idem, the Court of Appeal and the tribunal, at least insofar as that is a relevant consideration at certification. As I've already shown you, in considering whether the data put forward by this applicant was sufficient, the tribunal was acting pursuant, therefore, to the legislation. which imposes that obligation upon it. The tribunal didn't reject this application for a CPO because it failed on the merits. It rejected this application because the applicant had failed to satisfy the tribunal that the data necessary to apply his methodology would in fact be available, a test that the Court of Appeal agreed was a relevant test. Now, it's true, of course, that if a CPO had been granted and the applicant had failed at trial to produce the evidence necessary to apply his methodology, then his claim might again have failed. But it doesn't follow, arguing backwards, that the tribunal was thereby precluded from considering at the certification stage the preliminary assessment of whether data was likely to be available or not. The mere fact that an application fails to meet the certification standards and therefore fails overall doesn't suddenly turn it into a merits test at the certification stage. As I've shown you, the certification rules are different from the merits rules, strikeout and summary judgment. And the CAT in its judgment faithfully applies the certification rules. It does not wander into the realms of merits. You simply don't see that in its judgment. The second category of complaints that the Court of Appeal made about the tribunal are what I've loosely termed procedural complaints. Can we please go to MS 223? It's judgment paragraphs 52 to 53. And what the tribunal found was, what the Court of Appeal found was that the tribunal had carried out a mini trial. And the Court of Appeal says what this in practice involved was the applicants being cross-examined, was the applicant's experts being cross-examined at a pre-disclosure stage in the proceedings about their ability to prove the claim at trial by reference to sources of evidence which they had identified but had not yet been fully able to analyse or assess. And the Court of Appeal said the tribunal gave minimal weight to the experts' own preliminary assessment that there had been pass on of the overcharges to consumers. Again, our submission, Mastercard's submission, is that the tribunal did not commit any error of law in this regard. I've shown you, first of all, the tribunal expressly recognised at paragraph 57 of its judgment that an application for a CPO is not a mini trial. Under the Act and its own rules, it was open to the tribunal to question the applicant's experts and to allow Mastercard to ask questions of those experts. There was nothing in the legislation or rules that precluded the tribunal from conducting the hearing in that way. And indeed, the paragraph 61D of the applicant's written case at MS 182 states, it would have been lawful for the tribunal to ask the experts questions in order to establish whether or not there was a realistic prospect that there would be data available for the experts to apply to their methodology such that loss could appropriately be determined in common. So the applicant accepts that questioning of its experts on relevant matters, on matters relevant to certification, was permissible. The questioning of the experts was led by the tribunal, not by Mastercard. The tribunal asked questions before Mastercard. Mastercard subsequently cross-examined the experts to, I quote, a limited extent, unquote. And one sees that in tribunal judgment paragraph 5, that's MS 240. The consideration of the experts' evidence by the tribunal was not adversarial because Mastercard did not submit any expert evidence of its own. The tribunal was not engaged in weighing up competing expert evidence. It was merely considering the evidence put forward by the applicant. The tribunal was not seeking to resolve any disputed points of fact or expert opinion. It was asking questions to understand and clarify the methodology proposed by the experts and the availability of the data that they said was necessary to apply their methodology. The tribunal's questions gave the experts the opportunity to explain and expand on their proposed methodology. And providing this opportunity was an advantage, not a disadvantage to the applicant. I've already shown you, but you may want to look briefly again at paragraph 76 of the tribunal judgment, MS 265. Overall, we recognise that the methodology put forward by the experts in their oral evidence in response to the tribunal's questioning is considerably more sophisticated and nuanced than that set out rather briefly in their experts' report. So the experts were encouraged by the tribunal to develop their reasoning. And next, there is no legal requirement on the tribunal to take all expert evidence put before it at face value. On the contrary, under Rule 79(1) of the tribunal rules, the tribunal only has power to make a CPO if it is satisfied by the proposed class representative that the claims are suitable to be brought in collective proceedings. It's quite clear from the legislation that the tribunal's role in certification hearings is not that simply of a supine rubber stamp. And as a result of the tribunal's questions, it became apparent that certain statements in the experts' reports were unsustainable or not maintained by the experts themselves. Could you please go to MS 127, paragraph 85. This is Mastercard's written case. You'll see we give 3 examples there of where, as a result of the oral evidence, it became clear that the expert's position was either unsustainable or not maintained. So again, in our submission, there's no error of law in relation to the procedure adopted by the tribunal in respect of expert evidence. The final category of complaint goes to the so-called continuing process of a collective action. Can we go back to the Court of Appeal judgment, MS 224, paragraph 53. And we need to pick it up really at the second sentence, the cat self-direction at the end of 57 down to the end of that paragraph. And the Court of Appeal found that the tribunal ignored the fact that certification is a continuing process under which a collective proceedings order may be varied or revoked at any time. Now, it's certainly correct that there is a power to vary or revoke a CPO at any time. That's section 47B sub 9 of the Competition Act 1998. It's at MS 1152, which simply says the tribunal may vary or revoke a collective proceedings order at any time. But the fact that the tribunal has power to vary or revoke a CPO at any time does not displace the obligation on the tribunal under section 47B sub 5 only to make a CPO in the first place if it considers that the statutory preconditions are satisfied. These are preconditions. They have to be satisfied. A CPO shouldn't be granted, let alone revoked or varied, unless and until the tribunal is satisfied the conditions have been satisfied. So the possible revocation of a CPO does not excuse the tribunal from ensuring that statutory conditions are met at the time when a CPO is granted. Lord, I note the time, and everyone's probably hungry and had enough of me.
No, we've certainly not had enough of you, Mr. Hoskin.
I thought you were going to say I'm not that hungry.
This is merely an appetizer, I'm sure. Well, if it suits you to break off now, we'll break off and we'll sit again at 2 o'clock.
2 o'clock. Thank you very much.
Thank you very much indeed. Thank you.